We are very glad you are here for today's webinar, and on behalf of all my colleagues in our Boston and Florida offices, as well as here in California, happy holidays. We're going to try to be time sensitive, try to run around 30 minutes and respect your calendars, so we will get right to it. I think that a little context would be helpful for what we're going to try to accomplish today. Some introductory remarks, a little bit about, what the relevant ERISA rules are that one would consider for having an ERISA policy. That also involves, understanding the kind of service platform you're on, the different roles that you or other advisors might play, different kinds of compensation, and then we'll highlight some of the problem areas that we tend to see, the more common ones anyway, in terms of situations that may have been mitigated or relieved somewhat if there had been a good policy and procedure in place. And then we'll try to wrap it up with a couple of takeaways for you to consider. So first, just a little perspective. From what we see at the law firm, there's a lot of disparity in terms of the ERISA policies and procedures. Some firms have them, some firms don't. Some firms have very robust policies and procedures, other firms have bare bones. So it's really hard to get a uniform application of these policies and procedures out there in the marketplace. We're concerned about it because as counsel, we're often brought in on situations, where there's an audit, maybe an SEC audit or a DOL audit, or a problem's been identified, and obviously you want to backtrack and look at your operations and controls and try to see, what has happened. So we think that's an area that stands maybe some improvement in a lot of places, and that's something that we would like to talk about it with you. So just to put a little, context on it, when people think about compliance manuals and procedures and have it tends to kind of fall under the penumbra of the securities law. And, for most of its history, the Advisors Act, didn't really require any written compliance policies and procedures. But when the rule was adopted, I think it was back in 2003, 2064-7, it became clear that an advisor or anyone that actually had to register, had to establish and implement written policies that were designed to prevent violations of the Advisors Act and to review those policies annually for effectiveness. And the broker-dealer regime has similar kind of requirements for written supervisory policies and procedures under NASD FINRA rules. And then we have, of course, Rule 204A-1, which requires advisors to adopt a code of ethics, setting forth the standard of conduct. What level of conduct does one need to satisfy in terms of delivering services? So, from our perspective, when an advisor or broker-dealer is providing services to a plan, given the fact that an advisor or broker-dealer entity already has these obligations under the securities laws, it seems to follow that in delivering retirement plan products and services, you would really not be meeting your standards if you didn't have something in place for the ERISA piece as well. And there's no specific content or format that's required. It's generally understood to mean that something, some sort of comprehensive coverage in terms of the scope and relevancy of your platform must be addressed. We know the SEC is interested in this on the ERISA side, as is the Department of Labor. So I think today, we'll just try to talk a little bit about some of the things that you want to identify that could be problem areas that are ripe for being the subject of policies and procedures. And again, just to, from the ERISA perspective, even if it's not a direct requirement under the Advisors Act or under the Exchange Act or FINRA rules, just from a best practices point of view as a ERISA fiduciary, I mean, clearly it seems that you would want to be fostering, ERISA compliance with the kind of services that you're providing. And I want to point out just finally that when we talk about some of these things, sometimes terminology is used interchangeably. When we talk about a policy, we're talking about, a rule, if you will, or substantive requirements. And, procedures are a little more granular, a little more detailed, and that's really the how-to, the how to implement. So let's talk about first, if you're thinking about compliance issues and policies and procedures, well, what are the rules that you would need to, what are the rules you need to be thinking about in terms of, having policies and procedures? I mean, clearly, in terms of if you're providing a fiduciary service, it breaks down into, fiduciary standard of care, fiduciary duty, and the rules on fiduciary self-dealing. And then again, you have to ask yourself, well, am I a fiduciary? When am I a fiduciary? Now, we know that a lot of you have listened to our webinars before and already up to speed on some of these issues, but I'm just going to recast them today just to make sure that we have the right context for thinking about how it fits in the world of policies and procedures. ERISA, the Internal Revenue Code as well on the, non-ERISA governed plan side, they really provide for a functional test for purposes of determining whether you're acting as a fiduciary. It doesn't really matter what the documents say per se, though good documents are important. Every plan will have a named fiduciary. So a fiduciary is going to be, when all is said and done, a person that has some sort of discretionary authority or discretionary control over the management of the plan, or who renders investment advice for a fee, or perhaps as a plan has some sort of administrative discretion over the plan. There are really three different kinds. We all want to keep our eyes open. We know that this is an evolving area with the potential for new DOL regulations at some point in the interest the SEC has taken as well. I don't have a crystal ball today. I'm not sure where that is all going to go. I'm not going to place my bet publicly today anyway, but it's something that we really need to be aware of. So in terms of these fiduciary rules, then I think in terms of having policies and procedures, you need to ask yourself, well, what kind of plan am I dealing with? If I'm a fiduciary and I'm dealing with an ERISA governed plan, then obviously I need to be thinking about my duty or standard of care. That involves acting with prudence and diligence, acting in the best interest of participants. It also involves, the diversification of investments to minimize the risk of losses, the duty to diversify, and the duty to follow, plan terms. Any violation of a standard, can result in personal liability to you. So what does that mean? I mean, in terms of really having policies and procedures in place to meet this standard of care, I think you want to really be thinking about it in terms of how can you evidence the fact that you've given, the right kind of consideration to factors such as whether an investment is likely to further the purpose of the plan, given the risk that you're taking, diversification needs, liquidity needs, the return of the plan. How can you show that decisions that you make with regard to one plan are appropriate given the advice or recommendations you might have made for another plan? How do you know that your investment recommendations conform to the plan's governing documents? How do you know whether you have the right voting, if you're exercising discretion, have some sort of voting powers? How do you know whether your voting or tender decisions are appropriate? So you really need to think about, your day-to-day operations in light of these ERISA fiduciary requirements as to your standards of care, when you're dealing with plan assets. I think you also need to think about it in terms of the self-dealing aspect. This would involve, ERISA plans and IRA accounts, for example. And you have self-dealing concerns that would forbid you from, dealing with the assets of the plan in your own interest, or for getting kickbacks and those sort of things. And you all know that the Internal Revenue Code kind of mirrors ERISA in this regard. So, the failure to satisfy, those concerns is going to trigger some fairly dire consequences unless you have, proper procedures in place to catch yourself. and or unless you can do it in a way that fits within an exemption. I think when you take away the fiduciary side, a lot of times you're providing services or doing things as a non-fiduciary, and you also need to be thinking about, if you're an advisor or a broker or a party, if you're not acting in a fiduciary capacity per se, but you need to understand that you and your affiliates are going to be considered, a party in interest or a disqualified person under ERISA and the code, and there are some very broad prohibitions, here as well. And that they're actually very broad. They're almost circular. They almost treat every transaction between the plan and the party in interest is prohibited unless it's otherwise exempted. For example, direct or indirect sales or exchanges or leases or lending of credit. And the thing about these transactions is that these are all per se, and it doesn't matter what your intent was or how hard you tried to satisfy it. So, in the absence of an appropriate exemption, you're going to end up with an excise tax liability for violating this prohibition. So, you have the consequences of party and interest rules that lead to excise tax, fiduciary rules that lead to fiduciary personal liability, or maybe equitable kind of relief, the potential for DOL penalties. It's a lot to think about, and you also need to be tracking your potential co-fiduciary liability under ERISA. You need to really be aware of what other who are the other players involved in these transactions, because as a co-fiduciary, if you knowingly are engaged in someone else's breach, or if you're aware of it but you fail to make a reasonable effort to remedy it, you're going to trigger some liability. That, and I would say co-fiduciary liability and bonding are other things to keep in mind. Brokers and dealers are exempt from bonding requirements to the extent that they would otherwise apply under ERISA. If you're subject to the FINRA fidelity bond requirements. But we see a lot of confusion around distinguishing between E&O insurance and bonding requirements, and you should have policies and procedures in place for those. Then of course there's the good old 408B2 that we've spoken about a lot over the last year or two. I'm not going to dig back into it now, other than to say that it remains a very important disclosure obligation. So you have your fiduciary rules. You also kind of need to understand, kind of the platform you're on, I think, in order to have a context for, what your internal controls look like. Who are the other players? Who else is involved? I mean, typically we see, record keepers that are, tracking accounts and investment transactions. They might be the gateway to the actual investment platform. Sometimes they're affiliated with other parties, such as a fund provider or annuity provider. Sometimes they're not. It's important to have those distinctions well in hand. You have TPAs that are more, day-to-day plan testing and operational. They handle IRS filings. Then, of course, you have a host of different kinds of advisory services that might be on the platform. They can be fiduciary or non-fiduciary, plan level or participant level. It can be investment-related or non-investment, some other general consulting-related kind of service. And of course, you've always got other parties to think about in addition to these key parties. There's a trustee, there's a named administrator out there. The plan might have other fiduciaries that they've designated internally. So it's really important to kind of track the platform that you're on and who the players are. And what do they do? Again, just for the sake of having a framework for today's discussion on policies. We all know that advisors, come in many flavors. We have, non-discretionary advice. We have discretionary advice. They both fall technically under ERISA 321, though discretionary advisors usually are delivering services in a manner that also involves the risk allocation, the shifting of significant fiduciary liability to that manager from the plan sponsor. Those are known as 338 advisors. And then you have people that are just doing something in a non-fiduciary capacity. Broker-dealers are arguably affecting a securities transaction as compared to providing investment advice or something more than incidental advice. Or there could be general consultative services. This might be, education services that are provided to participants. So there's a lot of different roles that can be played, and it's important to understand those. And there are different ways that people are getting paid. I think it's important to have a good grip on the different categories of compensation. TPAs, typically we see them getting direct compensation, sometimes indirect compensation, for a product provider, 12B1s or some other form of revenue sharing. Record keepers usually have a variety of both. Obviously advisors, the trend now of course is for investment advisors a direct percentage of asset fees. People on the brokerage side are still looking at commissions and other forms of revenue sharing and 12B1 fees. You might be a dual registered entity with both, and you just think about offsets. The every different platform has its own regime of compensation. Who gets paid? Does it go directly back to another service provider? Does it go to an ERISA account? There's a lot there to keep track of, and I think that of course the main concern from a policy point of view, in addition to making the right disclosures and being able to explain to everyone where your money comes from, who's paying who, so on and so forth, is that it's easy to cross up and go against the ban on variable compensation that would apply to fiduciaries. So you see advisors typically are trying to maintain level fees, provide for offsets. Conversely, you'll see we see broker dealers that are typically looking to avoid fiduciary status so they can have varying commission rates, or maybe as a backup position, sometimes we see broker dealers just having a cap on fees, some sort of uniform commission structure in case they inadvertently cross the line. But I think those are some of the different pieces. So when you stop and think about it, I know that was a little bit of a rehash for some things that you're very familiar with. When you think about the fiduciary duty, prohibited transactions, the different players, the different bundling of services, different reporting and disclosure requirements, the different kinds of services that are provided, sales and purchases, leases, record keeping, extension of credit. There's so many different things that can be done, so many different service areas. When you put them all together, I think you can obviously appreciate that it can get pretty complicated and it's easy to make mistakes, and that's why it's good to have some sort of, we think it's good to have a guideline or manual in place that governs the areas that are most relevant to your firm or your platform to use for internal controls and for general education. I think some of the areas that we see, probably the number one area that we see that leads to these kind of errors that perhaps policies and procedures would have been able to control is the failure to identify and properly tag ERISA accounts or IRA type accounts that are governed by the code provisions but are not ERISA accounts per se. It's really important when you're out there in the marketplace to identify and properly classify your different client accounts. You could have ERISA governed plans, IRAs, KEO plans, one-person plans. There could be governmental plans. There are a lot of different flavors out there, and they all fall under different levels, or they don't fall under ERISA or certain requirements. But I think it's really, really important to kind of know what you have, because it's going to impact how you get, who you pay and how you get paid, what that form of compensation is, your ability to share revenues, your ability to set compensation, and that's really one of the big gating factors right up front, to know what you have. We have come across situations where people sometimes for very good reasons, sometimes just for lack of awareness, just kind of lost track of what they had or what they were holding, and when they finally became aware of it, it takes a pretty good effort to unscramble things and put it back to right. I think another area to think about is for those of you that are involved with managing funds or any kind of pooled investments, to have a good perspective on understanding how the plan assets are defined under ERISA, the 25% rule and some other things in terms of knowing when you have plan assets under your charge and you don't. I know that on the audit trail, when the SEC or the DOL come into your firm, they're going to ask for, or they would certainly expect to see the proper identification of any kind of fiduciary account, and all kinds, including ERISA accounts. So I think it's incumbent upon service providers to have a good grasp and understanding of what they have in that regard. Again, the consequence is if you don't get it right, you could be just operating on the wrong standard of care. You could be inadvertently crossing the line of prohibited transactions because you're getting the wrong kind of compensation, the wrong level of compensation. Maybe you're not making the right disclosures. There could ultimately be, reporting problems back on the 5500s and other required forms. So this is the big gateway up front, the need to understand what you have. And obviously it implicates, your bonding and perhaps your need for fiduciary insurance as well. The general area that we see, I'll just call it the legal, I call it the paperwork on this slide. Just generally speaking, just legal terms and conditions and all your paperwork. What's the process for making sure that your agreements, your account opening forms, your Form ADV, if in fact you're an investment advisor, that they're all consistent, that they're accurate, that they reflect best practices, that they're compliant. We see a lot of gaps and variances in this area, and a procedure to have someone check off and be in charge of document control back in your firm, would just be a very simplified example of something that you could do to make sure that you have congruity among all these forms in terms of compliance. Sometimes we see just the failure to get certain basic representations in the agreement. Sometimes we see failure to have permission for fees to be paid out of the plan assets. So making sure that all the paperwork is congruent and compliant with ERISA is very important. Just generally speaking, again, just the ERISA fiduciary standards, assuming that you know what they are and you're doing your best effort to act as a fiduciary, who is sitting back in the firm and really taking stock of when you or your affiliates are providing fiduciary services and when you're not, and what kind of procedures do you have in place to show that you're, the investment decisions you make, how you vote on, on tender offers or proxy if you have those powers, how in fact you receive and track, client IPSs or other governing plan documents. How do you really track that and know that you're discharging all your activities in a manner that's compliant with ERISA's fiduciary standards? Very often you'll take a good client representation and warranty in the paperwork, and we think if it's well prepared and well written and properly scoped, if you will, that'll go a long way toward handling that issue. I think another area that we see sometimes people miss is, and it could be remedied with a good procedure in place, good checks and balances, just understanding when you might have some self-dealing transactions. The most common ones we see are maybe affiliated brokerage. Of course, there's an exemption. There's several ways to get around that. The most common is the prohibited transaction exemption 86-128. We see proprietary investments, which creates a problem in terms of the compensation you're getting. But of course, there are ways to work around that as well. To have a policy in terms of fee offsets, or maybe use the Sun America type model that the DOL has published, or other models that are that are out there. Mutual funds, have the old exemption 77-4. Cross trading can be a problem. Where your advisor is representing both sides of a transaction, that could be a fiduciary violation. There are some prohibited transactions exemptions and statutory provisions that might provide relief when you have market quotations that are readily available to do this kind of thing. But again, you need to have a policy in place that you can show that you handled the trade in a certain manner. And just generally speaking, revenue sharing, it's beyond the scope of really even one slide. Obviously, we all know that revenue sharing is very important. It's part of the financial services industry with plans, and it's very complex. And I think that it's really important to take a look at the different streams of revenue sharing and other sorts of payments that are coming in, and making sure that you either avoid them because you don't want to inadvertently have a prohibited transaction, or that you handle it in a manner that comports with published guidelines from the Department of Labor. They have some, key advisory opinions that are out. And sometimes, every now and then, we come across something where we thought it might be a prohibited transaction or a problem, but it's actually not. So maybe just the way it's structured, it'll come through relatively clean. Again, on the non-fiduciary side, you have to be thinking about party and interest transactions, and that could involve, as we said earlier, purchases and sales, extensions of credit, all kinds of other activities, leasing. And there's just a host of exemptions that are available, necessary services, if you will, under 408B2 of ERISA. You have the QPAM exemption for investment managers. There's things that can be handled to address block trading and cross trading. Principal trading is generally not a good one. We stay away from that one. Not too much relief available there. Or the very broad service provider exemption that was added back in, I guess that was back in 06 with the Pension Protection Act. It's also interesting the way some of these things have evolved now is that sometimes more than one exemption is available. There might be more than one way to get relief. Other things that we see that we'd like you to be aware of and perhaps merit a good policy. Sometimes, you have the wrong people, if you will. There are certain disqualified employees that are barred from providing services. That's in ERISA 411. The gifts, the anti-kickback rule, understanding where the DOL enforcement position is on that in terms of gifts is important. Solicitation arrangements can be problematic sometimes. Is the solicitor a fiduciary? So I think there's a right way and a wrong way to do that, and you should have procedures in place and checks and balances in place for all the documentation that's used. Occasionally we get questions on social investing or targeted investments, and there's some published guidance on those things. And I think for some, even though we don't see that much in terms of performance fees, there are some more at the pooled investment level where people are looking for performance fees. The Advisors Act has its own regime on fulcrum fees and other things, but there is some published guidance from the ERISA side as well, which gives some examples of performance fees that were acceptable. Other things that we think might be ripe for procedures would involve just how you work with qualified default investment alternatives, kind of soft dollars, and something that we've seen over the last couple of years as people transition toward advisory platforms. Just and maybe you have more than one office, or you're in multiple states, or you're a larger organization and you have reps and IARs in multiple locations, is having some sort of control in place as to who you are going to allow to provide fiduciary services. What kind of credentials do they have? What kind of documents do they use? Is there a requisite plan size or a number of plans they have to be in this? Do they have to use documents that are pre-approved by the Home Office, or can they use their own? What kind of advisory programs can they provide? So we think we see some program development along those lines that's pretty important. So having heard about all these things, all these rules and potential problems, where does that leave you as a practical matter? We think that probably the best way to approach it is to think about step number one. You have to identify all your ERISA and IRA accounts. You have to know what you have, and then you have to determine when and where you're acting as a fiduciary in terms of providing services, and establish appropriate procedures. You have to consider how you are impacted by the fiduciary rules as well as the party and interest rules when you're in a non-fiduciary capacity, and determine either to stay away from certain transactions or identify how you fit within the relevant exemptions, and make sure you have policies and controls in place that fit you where you want to be. So when you end up, you want to have written policies and procedures to implement those policies, and kind of wrap them up perhaps into an ERISA manual or an ERISA code, if you will. And I think that manual would cover topics like how accounts that are subject to ERISA are identified in your organization, an identification of an explanation of what a fiduciary is, and the process that you use for identifying what accounts you handle as a fiduciary, maybe a summary of your procedures as your own investment committee or advisory committee, and how you follow those procedures to demonstrate compliance with ERISA's requirements. A summary of any self-dealing or party and interest type transactions that are applicable to your accounts and your platform and your services. And then an identification of the specific exemptions that you wish to avail yourself of if you are going to handle those transactions in a manner that's permitted under the code. So obviously there's a lot to think about there. We're going to stay true to our timeline. Thank you very, very much for attending today. On behalf of all my colleagues, Marcia Wagner, our Managing Director, John Sohn, who many of you know, the head of our fiduciary practice out of our Boston office, and all of our other colleagues in the firm. Happy holidays, and thank you very much for attending. If you have any questions and want to shoot me an email, please do so. You have my contact information here, and we would be glad to respond. Thank you very much.